This is exciting stuff. We'll try and keep this fun and entertaining, but the topic is the law, so don't hold us to too high an expectation. I think the schedule is for us to to talk for about 45 minutes or so on intellectual property and corporate legal issues for you, and then open it up for question and answer at the end. But that said, if there's anything along the way that, pause me if there's anything you want any more information on, because this is going to be kind of a lot pretty fast. So we won't be able to go into a whole lot of depth on any one of the issues right now. So, do raise a hand if you want to pause us and go into a little bit deeper on any of these subjects. So we are going to be talking about law, so I have to get the disclaimer out of the way to begin with. This is an informational presentation, and you should not consider this to be legal advice. If you have particular legal issues, you should contact your attorney, of which we are not yet, although we would be happy to talk with you about that at some point if you'd like. All right, so the presentation is kind of broken into two parts. The first part is talking about IP and protecting intellectual property. The second part is going to be talking about creating your startup entity and financing. And I'm going to be covering the patent part. I'm the patent attorney. Dan's the corporate attorney, aside from the difference in the jeans versus the dress pants and the beard versus the clean shaven. He's also the one that is the more polished speaker, and I'm the one that there's a joke about patent attorneys. They say, how can you tell a patent attorney from another? How can you tell an outgoing patent attorney? An outgoing patent attorney is the attorney that's looking at the other person's shoes instead of their own. So anyway, patent attorneys have kind of a bad rep. So anyway. So we'll just jump right in here and get started on the first part. So protecting your ideas and intangible assets. What is IP and why is IP important? So I'm actually just going to open this up really quickly to you guys and see if we can get from the audience kind of a summary. What do you guys think IP is? When you think of IP, what do you think? Anybody?
Intellectual property.
Intellectual property. Okay, so what is intellectual property? Okay, copyright's an example. That's a great topic. Copyrights, patents, trademarks, trade secrets. We're going to talk about all those in a little bit of detail. But in general, intellectual property is a property right that you obtain that protects your inventions or innovations or other intangible assets. And so why is that important? Because without intellectual property, your ideas, your hard work, your innovations can be copied and used by other people. So if you're a startup company, you've developed some new technology and you go talk to another company, if you don't have those ideas protected in some way, there's nothing stopping them from taking that idea and saying, wow, it's a great idea. And we've got a lot of resources to put towards doing that and copying your idea. So intellectual property is the protection that's available to help protect your investment in time and energy and money to develop those ideas. So, along those same lines, it's great to innovate. A lot of companies think innovation is kind of the key to success, innovate fast. But innovation alone really isn't enough for the reason that I mentioned that before. Despite the best innovation, the smartest, you might have the smartest group of engineers and programmers and developers, that you're still not going to be able to compete with another company, a large company that has resources to put towards something if you don't have some way of protecting those ideas. So innovation plus protection is what is going to equal prosperity or success. And I have a couple slides here just at the beginning to kind of highlight, how the market sees these things. So back in 1970, and how many people in the room are alive in 1970? One. What? And I can't even raise my hand either. I'm sorry, Howard. In 1970, this is what the breakdown of the S&P 500 looked like. The value associated with the S&P 500. About 85% of the value of the S&P 500 in 1970 was in tangible assets, so plant, factory, equipment, machines, and only 15% was in some form of intangible asset like intellectual property or know-how. Flash forward to today, and that is completely flip-flopped. to where today you have somewhere between 80 and 85% of the value of the S&P 500 is in some form of intangible asset or intellectual property. That's a reflection on the change in the US economy from a manufacturing economy to a services economy, and now to an intellectual or IP economy. And during the same time, we've seen a change from companies like IBM, GM, and GE and other companies that are making a lot of things and doing the manufacturing in the US. And this is IBM, by the way, this is back when they're still making typewriters, and computers, manufacturing computers. Today, IBM still exists, but they're not making devices in the way that they were. Flash forward to today, you have some of the same companies here in the energy space, but a lot of the other companies are really IP-based companies. I want to pause here for just a second. I'll put a couple of events up here. But I want to pause here for just a second and ask you, these companies up here, what do these companies make? What does Apple make, for instance? Anybody? What does Apple make? iPhones. Consumer electronics. Software. You guys, that's the closest, but you guys are both wrong, actually, when it comes to that. Apple doesn't make anything when it comes to hardware. What Apple makes is intellectual property. They're developing intellectual property, and they're having other companies, by and large, manufacture all of their equipment. Apple's not manufacturing any of their devices or hardware themselves. They have all of that farmed out. So Apple is in the business of developing intellectual property. They do have, obviously, software developers, and they're writing software and code, and that would be the closest thing to an actual product that I would say Apple is making. But I would argue that's really even essentially intellectual property, because, as Dan will talk about later, as soon as you write your software code, it's protected by copyright. And so this is just a big shift. And I have one more slide just to kind of illustrate the same point. This is saying kind of the same thing in a little bit different way. But you can see here, from 1975 to today, the shift in percentage of the economy that is attributable to intellectual property or intangible assets. And one thing that this chart shows that the other one doesn't is, we're seeing this start to level out here towards the end. And that's probably a reflection of two things. Number one, it's approaching a very high percentage, and it's never going to get to completely 100%. And number two, there's been a few trends in the last few years that have actually gone towards weakening intellectual property, and in particular patents in some ways. And so we're starting to see a little bit less investment in IP, a little bit more investment in physical assets. And another reason for that is we've also seen China and India and the labor costs in those countries go up quite a bit. So they're bringing back some of that manufacturing to the US. So I think this may be about the peak. I don't foresee it going down a lot from there in the near future, but I also don't see it going higher than that. If that wasn't enough to convince you that intellectual property is important for your company in the United States, I think this slide will kind of drive the point home. And I'm just going to put up some news headlines here. And I'm not going to say a whole lot about this other than to say that these are some pretty big numbers. And these big numbers are largely attributable to the intellectual property that was developed by the companies. The first one up here on the top left is a consortium of companies that bought Nortel's patents when not to be out, and they did that largely to keep them from going into the hands of Google. So Google, not wanting to be outdone and not wanting to be left out the next time around, pays $12.5 billion for Motorola Mobility's wireless, largely for their wireless patents. Turns out, a few years later, they actually turn around and spin out the operating company and keep the IP. So even more clearly, a move primarily for the intellectual property. You guys have probably all seen some of the headlines about the Apple-Samsung patent battle that's gone on and the dollars that have been associated with that. Microsoft buys a bunch of AOL's patents and then turns around and sells half of them to Facebook or sells some of them to Facebook for half what they paid. And then fairly recently, Google's acquisition of Nest, which was a company that you guys are probably familiar with Nest. They make the smart thermostats and smoke alarms. This company has had around 275 patents. There was also a product design team and some other things that went along with that. But largely, a lot of the people have called that largely attributable to the IP, and $3.2 billion for 275 patent assets. I'll let you guys do the math, but that's a lot for IP. So hopefully I've convinced you that IP is important to your company for a variety of reasons there, that the market thinks that IP is important. So how do you protect your innovations? Now that you know IP is important, you've got a startup company, you guys are all working on business plans for different technologies, and I can say with certainty that every single one of your business plans, your businesses, has some intellectual property component to it. I have no doubt. And so where does it start? It starts with know-how, and your company, you as an individual in your company, is developing know-how every single day. Everything that you're working on is creating some kind of know-how. And eventually that know-how turns into some sort of identifiable, protectable subject matter. That could be new product designs or product improvements. It could be brand names, logos, web design, all these different things, everything to product catalogs and customer supply lists. All of those things are things that you can discreetly identify. This is something I created and something I made. And what's going to be important for you guys to start thinking about with your companies is putting in place the processes and just the intentional thought process of recognizing those things, taking a step back and saying, oh, I just created something. And then the next question is, should I protect it? And the answer isn't always going to be yes, but in a lot of cases, the answer may be yes. We should protect it in some way. And so we'll talk a little bit about this. So the next question, once you've identified some subject matter for your company that you've created, maybe it's a new product design, or maybe it's some software code or an app that you've developed, maybe it's a customer list. The next question is, are there IP protections available for this subject matter? And the answer to that is probably yes. The four main types of IP protections that we're going to talk about are patents, trademarks, copyrights, and trade secrets. I have often thought of contract as kind of a fifth kind of intellectual property. It's not traditionally called intellectual property, but it's a way for you to, anything that doesn't fit in cleanly in one of these buckets, you can probably protect it in some way with a contract, whether that's a non-disclosure agreement or a supply contract or any number of other things. So a contract is something that helps tie these things together and also allows you to supplement what maybe you can't get protection for exactly how you want through the traditional intellectual property realms. The next question is, okay, so it's protectable, and we've figured out that maybe it's protectable through one or more of these types of intellectual property. The next question is it worth protecting? And not every innovation is going to be worth protecting in some way. There's going to be certain things that you develop and you just say, well, this is a cool thing, but we're not going to take any affirmative steps to protect it. And those decisions are going to be business decisions that you make every day. A lot of them you're going to make probably subconsciously, but what I'm hoping that you come out of this with is the idea that you want to make more of those decisions consciously and actually be thinking about them. So if we leave you with one thing, that's what I hope it is, that you're identifying these issues and at least thinking about whether it makes sense to protect them. So some of the things that play into that cost-benefit analysis are, what kind of opportunities does this subject matter create to generate some revenue for your company? And that could be through licensing revenue or a sale of something. Another issue is, does this allow me to compete more effectively in the marketplace by having this intellectual property? If I can prevent a competitor from coming along and making something that's the same or very similar to my product, does that allow me to be more competitive in the marketplace? And then the third main item that I would put out there for you is the value, the asset value that you're creating. Especially as a startup company, one of the things that you may be doing is going out and trying to raise capital, raise financing, and it's going to be important that you can show that you have some assets when you do that. Otherwise, when you go to raise that financing, you're going to be giving away a lot of your company in order to get that financing in the door. So these patents and other intellectual property assets are ways that you can create value in your company. And there's very few other assets that you can generate that have such a high return on investment. So we saw some of those numbers on the other page of transactions. The least of those had an asset value of $250,000 plus per patent value. Now, not every single patent that you generate is going to be worth $250,000, but if that's an average that we can work with, I can tell you that the cost of obtaining a patent is far, far less than that. On the average cost to obtain a patent is in the $20,000 to $30,000 range. So what other asset can you go out and create, think of in your own mind, create, spend $20,000 to $30,000 on, and immediately it's worth $250,000. It's a pretty good return on investment. So be thinking about that as another cost-benefit analysis component. So with that, I'm going to transition over just a little bit and talk about a couple of the different types of intellectual property. And I'm going to cover the patent side of things, and then I'll turn it over to Dan to talk about the trademarks and copyrights, and then we'll kind of share responsibilities on some of that before he takes over the corporate stuff. So the first type of intellectual property that we're going to talk about is patents, and there's several different kinds of patents. The two main types of patents that you'll hear about are utility patents and design patents. There's also what's called a plant patent, and that protects different plant varieties, and I'm not an expert on that, so I'm not going to say much more than that. But WSU, being an agricultural school, has some intellectual property in the plant patent space. A fourth type of patent, which I'll talk about here when we're talking about utility patents, what's called a provisional patent. And a provisional patent application is really a type of utility patent. But a utility patent is what you typically think of. When someone says, I have a patent on something, you typically think of a utility patent. It's kind of the gold standard for patents. And it protects the functional aspects of your invention. And this can be a wide range of inventions, different machines, devices. So think of your iPhones and your tablets, your computers, the hardware, the devices, things like that. Machines. It can also cover the processes of making things. So if you develop a new process of making a chemical composition or something that is protectable by patent. It can also be used to protect software. And this is one thing that we'll see, that certain types of intellectual property or innovations that you have may be protectable by multiple types of intellectual property. Software is one of those. And it can also, at least theoretically, be used to protect business method patents, or business methods. So if you come up with a new way of doing business that gives you a competitive advantage, that's something you could theoretically protect with a patent. What we've found over the last 5 to 10 years is that the courts are being more and more critical of those pure business method patents. And if they characterize your invention as being merely an abstract idea, then you're not going to be able to get patent protection for that. So what that really effectively means is your business method needs to be tied in some way to some piece of hardware or computer software in order for it to be clearly patentable. There are some inventions that may still, business method inventions that may still be able to be patentable without that, but to fit it clearly within the patent protection, it probably needs to be tied to some sort of software or hardware. But utility patent can be used to protect really virtually anything. The Supreme Court once said that anything under the sun made by man can be patented. Now, there's a couple of requirements for something to be patentable. It has to be useful. Well, if you invented it, it's probably useful for something. Otherwise, why would you have invented it? It has to be novel. It's a pretty low standard. It just means that exactly what you invented can never have been done before. So we're not going to give you a patent if you didn't add something that didn't exist before. And then it has to be non-obvious. And non-obvious is where we spend most of our time arguing with the patent office and the courts to argue whether or not you're entitled to a patent. Because we have to be able to say that your invention adds something beyond the ordinary beyond the skill of one of ordinary skill in the art. So we have to show that you invented something that is truly inventive and non-obvious. Okay. Any questions about that so far? Okay. There are a few exceptions to what is patentable, and those things include, I already mentioned one, is abstract ideas, laws of nature, things that naturally occur in the environment. Those are things that are not protectable by patent. So if you go out and discover a new substance that occurred naturally in nature, you're not going to be able to get a patent on that, even though you're the first person that discovered it. Okay, so when you've come up with a new invention, you've applied for a patent, you've gotten your patent and it's been granted, what right does that give you? And I've sort of given you the answer there, but it gives you the right to exclude others from making, using, selling, offering for sale, or importing goods that infringe that patent. Okay? So you've gotten your patent and you want to go out and make your product. Does your patent give you the right to go out and make your product? Well, let's see. Let's go with a show of hands. How many people think your patent gives you the right to go out and make your product? Couple of hands, tentative hands, not sure. Okay, how many people think that it does not give you the right to go out and make your product? Okay, about the same, maybe a few more hands, and then everyone else, I'll assume, is hedging their bets and wait until I give you the answer. So the reality is, and this seems sort of counterintuitive at first, but the reality is a patent does not give you the right to do anything, to go out and affirmatively make your invention. What it gives you the right to do is to prevent somebody else from making your invention. So if you go out and get it, the hypothetical we often give is, let's just say, Dan is an aspiring entrepreneur and he invents the very first stool. Before Dan invented this stool, a stool didn't exist. And so Dan comes to me and I write him a patent application. The patent application describes his stool in great detail, and then it says, it ends with a claim. And the claim at the end of your patent is what defines the property right. And this claim in our patent says, a seating surface supported above the ground by at least 3 legs. That's what our claim says. And so Dan gets this patent, and he starts, and there are no other patents in this space. So his patent doesn't give him the right to go make a stool, but there's nothing else preventing him from doing that, so he goes out and starts making stools. What's your name? Here. Dan? Yeah. All right, so Dan comes along. Another Dan 2 comes along and says, stools, well, stools are great, but gosh, when I get home at the end of the day, I'm kind of tired. I want to be able to lean back in my chair, or lean back. So I'm going to he comes up with this idea of a chair. And this chair is great because it has several improvements over the stool. It has a back that he can lean against, and it has some arm rests to rest his arms on. And so Dan comes to us, or his patent attorney, maybe another patent attorney, because maybe we can't work for both of you, because that might be a conflict of interest. But he comes to another patent attorney, and his patent attorney is a good patent attorney as well, and writes him a patent application, because his invention is novel. It's never been done before. Nobody's invented a chair before. And at the time, stools were new, so this is maybe non-obvious. Nobody had thought to put a back or arms on this thing. So assuming those two things are true, he gets a patent on a chair. And the patent on his chair says, a seating surface supported above the ground on at least 3 legs, and including a backrest and 2 arm rests. And so he gets a patent, and he goes out and he wants to start making chairs. So what's going to happen when Dan goes out and starts making chairs? Dan number 1 is going to come sue Dan number 2, or he's going to at least send him a letter that says, hey, you're infringing my patent. So that sort of illustrates the point that just because Dan 2 got his patent doesn't mean that he can necessarily go out and make his invention without infringing somebody else's patent. But the reality is that if everybody really wants chairs, I mean, you're all sitting in chairs in the audience. You're not sitting on stools. So clearly the market wants chairs. So what's going to happen is what's going to happen if Dan starts making chairs? Dan number 1 starts making chairs. What are you going to do? You're going to go sue him because now he's infringing your patent. But the reality is you're probably not going to sue each other. The reality is you're going to get together and say, well, somebody should make chairs. The market wants chairs. And either you're going to cross-license your patents so you can both make stools and chairs, or Dan's going to license you to make chairs, but only chairs, and he's going to keep making stools, and you're going to pay him a royalty on your chairs that you make, or vice versa. So that's the reality of the way that this works. But the important thing for you guys is when you come up with an invention, just because you've applied for a patent doesn't mean that you can go out and start making that product without risking infringing someone else's patent. So there's really 2 questions that you probably are going to have when you go to talk to a patent attorney or you start thinking about filing a patent application. Number 1 is, can I get a patent on this? Does it meet the requirements? Is it novel, non-obvious, and useful? And question number 2 is, if I want to make this product, am I going to infringe somebody else's patent? And in order to answer that question, you have to go out and do a patent search and look and see what other patents are out there and read the claims. And that, I will not lie to you, is a very labor-intensive and daunting process. But I will also say that as a startup company, until you start making money and are successful, no one is going to care if you're infringing their patent. So that's maybe something else to file away in the back of your mind and think about as well. There's a question? Yeah.
Yeah. Do patent attorneys do that research?
Patent attorneys do that research. To answer both of those questions, that's certainly a question that an attorney can answer for you. The answer to the question, can I get a patent on this, is a much easier question to answer and a much easier search to do than the question, am I going to infringe someone else's patent? So accordingly, the price tags associated with those are a little bit different too. Often for startup companies, I encourage you guys to do a little bit of that research yourselves, and unless you find something that looks that looks scary, then I wouldn't necessarily encourage you to spend the money to pay a patent attorney to do that freedom to operate search, at least initially. But it depends on the circumstances, and again, I'm not advising you on your particular situation. But anyway, any other questions on utility patents? I have here at the bottom, the term of utility patent is 20 years from the filing date. So once you file your patent application, until it issues as a patent, until the end of its term is 20 years. So what that means is the reality is the first 2 to 3 years of that patent application's life, it probably spends it in the patent office being examined, which means you don't have a right yet. You just have a pending patent application. So some of your term is not expiring, what's the word I'm looking for? Continuing, going on while your application is still in the patent office being examined.
But it is valuable to be able to say patent pending sometimes.
Absolutely,
right?
Absolutely. So as soon as you file that application, you can mark your product patent pending, and it does give you some preliminary rights. You can't go sue anyone for infringement to stop them from doing anything, but once your application publishes, it puts people on notice that you have a patent application filed and may give you some rights later on for damages once your patent does issue. So the only other thing I want to mention about utility patents, I mentioned this concept of a provisional application. A provisional application is basically it's the same as a utility patent, except it's totally different. And what I mean by that is it protects the same, it can be used to protect the same sorts of things as a utility application, but it by itself will never actually turn into a patent right. It's just a placeholder to buy you 1 year within which to file your utility application. It doesn't have all the same formal requirements that a non-provisional application has, but it's a way for you to get a filing on file at the U.S. Patent Office so that you can go start talking to investors and other people without worrying about them being able to run off with your invention.
Do you want to tell them, I mean, there's only certain circumstances where we actually advise clients to pursue a provisional application. You want to talk about that because it could be applicable?
Sure, yeah. So provisional application is only as good as how much energy and effort you put into it. So there are very limited circumstances that we recommend filing a provisional application. It's not the situation where you can, it is the situation where you could literally file a napkin sketch of your invention. But that's probably not going to be a very valuable provisional to you because it's not going to support the claims that you ultimately want to file in your non-provisional application. So when you file a provisional application, the patent office is not even going to examine that document. They're just going to say, okay, thank you very much, and they'll file it, and they'll give you a number associated with it. So when a company comes to talk to us to file a patent application, sometimes they've heard of this provisional application, and I've heard, it's cheaper, and maybe we can do this for cheaper. Maybe we can do it for a little bit cheaper, but the reality is if you wanted to protect your invention and give you the rights that you ultimately are going to want, it's probably not going to be much cheaper because we're going to have to go through a lot of that same effort to really describe your invention in detail, be sure we understand all the different embodiments and variations of it, make sure that we've enabled one of ordinary skill in the art to practice your invention, which is one of the requirements, and that we've drafted the specification in a way that it supports the claims that you ultimately want to get to protect your invention. Where we do encourage clients to file these is, number one, if you don't have the resources to engage a patent attorney, the financial resources to engage a patent attorney to draft the application for you, and you're going to do it yourself, which you absolutely can do, and If you don't have the resources, I would totally encourage you to file your own provisional application, and there's lots of resources to help you do that. And if you file that, it's called filing pro se, and you can do that on your own with the patent office. The filing fee is relatively low. I think it's $130 for a small entity or something like that. That would be one example. The other example would be if one of our clients came to us and said, hey, we've got a trade show tomorrow and we're going to disclose this stuff. We need to be able to show it and talk about it tomorrow. Can you get something on file for us? We can't probably write a full non-provisional application for them in less than 24 hours. We have done it and we'll try, but that's not the ideal situation. So in that case, we would probably file a provisional application. We'd take whatever documentation they have, we would write some claims and draft it as much as we could and get what we could filed by that date. But those are kind of the limited circumstances for a provisional application. Anything less than that and you're really asking for trouble later on because it won't do what you want it to do. So. Spend a little bit less time on this, but quickly did want to talk about design patents. So with the utility patents, like I said, this is sort of the gold standard that protects your invention, your functional invention, what something does, how it works, that sort of thing. A design patent covers the ornamental aspects of a design. So there might be there are design patents on the iPhone, as well as utility patents on the iPhone. I think Dan maybe has a slide in here later. We'll go through that in more detail. But the design patent is going to cover the way this thing looks. So when you look at the iPhone, can you tell it's an iPhone? If so, what is it about it that you can tell is an iPhone? And those sorts of things. The shape of it, the color scheme of it, the materials, the look and feel of it. It cannot cover functional aspects. So design patent doesn't cover the function of an item at all. So what you see with a lot of design patents, it's consumer electronics, it's some certain amount of apparel, soft goods, shoes was a big area. Some of the car companies protect things with design patents for like the body style and shape of the cars, those sorts of things. And the protection that it gives you is very different. So with the utility application, we talked about the claim at the end of the patent, which is kind of you can think of it as a instruction list or a ingredient list that in order to infringe that claim, you have to do each one of those ingredients or each one of those items on the list. With a design patent, your claim is essentially the drawings. So you file some drawings that show the shape of the product, and and someone will infringe that claim if they make a product that looks like that thing, and it has to look very similar to the product. The test for infringement is basically would an ordinary observer, an ordinary consumer of this product be confused into thinking this product is the same as that product. So that's kind of the rights that a design patent gives you. And the term is different too with the design patent. I said that with the utility patent, the term is 20 years from your filing date. With a design patent, the term is 14 years from your issue date. So it's a shorter term, but it's from when it issues, not from when you file it. So, and actually they just extended this. I forgot to update this. They just extended this to 15 years when the US joined the Hague Convention, which is an international treaty on design patents. So any questions about design patents? It really depends on the facts. It could very well be. A lot of the actually, to give you a concrete example, a lot of the Apple-Samsung litigation has really been about design patents and a group of 4 to 6 design patents that on both the device itself and the user interface design that Apple got this $1 billion judgment was based on design patents, and that Samsung's phones look too much like the iPhone in some respects. And trade dress as well, although I think they lost on a lot of the trade dress. But so good question. The car, it could be that, or it could also be some functional aspects of the vehicles as well. Any other questions? Okay, so from here we're going to transition over to trademark, I think. Dan?
Let's see.
So
What's next?
Oh, down.
That's not right.
There you go.
All right, yeah, so trademarks. Now it gets exciting. No, I'm just kidding. Patents are exciting. So patents are king in the IP world. They're king. Except for, but they're king. Patents are king. And what, guys like Dave, patent attorneys, call patents are hard IP, and everything else is soft IP, right? Maybe because you need a hard science background to be a patent attorney. But I always counter that. I'm not sure if soft IP is really a nice term or a diss, but I always counter with, okay, what's the single most valuable piece of intellectual property in the world? Does anyone know? Does anyone want to guess? What's the single most valuable? Okay, so the Coca-Cola recipe, and that's a good example of a trade secret. A lot of people answer that way, but no.
Like my check mark or the Coca-Cola design.
All right, so it used to be that everyone answered that question, the Coca-Cola logo, right? Because everyone in the world recognizes the Coca-Cola logo. Even where Maria is in Africa right now, they probably know the Coca-Cola logo, and they have for years and years and years. But the single most valuable piece of intellectual property these days is, pull out your phone. It's not on my phone because I have a Samsung. Who has an Apple iPhone? Okay, what's on the back of your iPhone? The Apple. All right, so Apple's brand is the single most valuable piece of intellectual property in the world. It's like $300 billion or something by Forbes, okay?
The brand itself, $300 billion.
Yeah, the brand, yeah.
That's over half the valuation of it.
So, and you think about that though, right? So you think about, why do people buy this instead of that? A lot of times it's like, oh, well, I have an affinity for iPhones. So I see the Apple mark, I want to buy it. So trademarks are cool. They're important because they're valuable. They're important because they're everywhere. And they're important because they are applicable across any industry, any type of business. When Dave says that he can say with certainty that any of your startup businesses have some intellectual property component, that is true because at least you have a name, right? At least you have a mark that consumers or your customers can identify your goods or services so that they can come back and keep buying from you. Okay, so even the mom and pop grocery store has some intellectual property rights because they have a name, okay? I made a bad joke last year about where the cheapest place to buy 30 bombs in Pullman is of Busch Light, but I don't think that's not applicable here. We're not going to say it. So what are trademarks? Okay, it must be a word, slogan, logo, or a color scheme, or even a sound, or even maybe packaging design. Okay, so the most common trademarks are words like Google or Apple. Okay. The logos also, or everyone knows that's a trademark. Even my 3-year-old, when he was like 1.5, he can't read, but when we drove down the street and there was a Jimmy John's sign, he said, "Jimmy John's!" because he loves Jimmy John's sandwiches and he recognizes those trademarks. Okay, everyone knows what trademarks are. They're a source identifier. Even kids know that trademarks mean something, okay? He identifies that sandwich that he loves with that logo. But it can also be, like I said, a color scheme or even a sound. Harley-Davidson has a trademark for the potato sound of how their engines rev. Potato, 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 potato. NBC, ding, 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 that's trademarked. Okay, there's a trademark registration for that. Color schemes. Let's think of phone carriers like Sprint, T-Mobile, Verizon, AT&T. What color comes to your mind, Dan, when I say T-Mobile? Pink. What about AT&T? Yeah, blue. Well, yeah, maybe the orange thing's kind of like the Sprint thing. But yeah, no, that's right, the singular. That's right, blue and orange. You're right. So I'm wrong. Red, Verizon, right? Okay. So that's a great example of where colors alone can be trademarks. And in fact, there is litigation where I think there was a T-Mobile sued one of AT&T's subsidiaries that was using some pink, okay, and they won. Okay, so it must be that one of those things, a source identifier, used in commerce in association with the sale of your goods or services, okay? Has to be distinctive, and it can't be the same as someone else's, okay? So, so the thing with trademarks, unlike patents, with patents you don't have anything until the government says you have something, right? With trademarks, you have something, you have some rights as soon as you start using a mark in association with the sale of your goods or services. Okay, you have what's called common law trademark rights as soon as you make that first sale and consumers actually identify your mark with your goods or services, okay? Doesn't mean you shouldn't get a registration. In fact, a registration is a very good idea. It gives you nationwide presumption of exclusive ownership of that mark. And I have some great examples of that, but I won't go too far into it. But what a trademark right gives you is the right to protect against consumer confusion and or potentially dilution of your mark, okay? So consumer confusion, what is that? It's when consumers are confused, right? So that's easy. So that's the whole point of trademarks is I did all this work, right, to build my brand, right, so that people come to me instead of my competitors. So I get this property right in this trademark, my brand, whether it's the word, the logo, the color, whatever it is that I'm using for my branding. And part of that, the trade-off is consumers know that when they come to me, they're going to get high-quality goods or services, right? So if there's a great sandwich shop in town and Dave Devine tells me about, oh, you have to go to this place, Casano's. We'll say Casano's. There's a little Italian place up in Spokane. They have good sandwiches, Casano's. Okay, I find a Casano's, I go there, and it's a really crummy sandwich. Well, it's not the same Casano's. There's some trademark infringement there. I'm harmed as a consumer. Okay, so that's the point of trademark law. Unlike patents, the term for trademarks is potentially perpetual, okay? So you think of Coca-Cola, for instance. How old is the Coca-Cola logo? How old is their trademark rights? It goes back a really long time, okay, sometimes hundreds of years. As long as you keep using a trademark, you can have rights in it, okay?
Whereas even the best patent is going to expire after 20 years. There's nothing you can do about that.
Nothing you can do about it. Any questions about trademarks? I can talk for a couple hours just on trademarks. Trademarks are cool. They're fun.
One thing. So you said that when, as soon as they start using a mark in association with goods or services in commerce, they get common law trademark rights. What should they do at that point in time?
Yeah, that's a good point. So you guys are familiar with the TM symbol? The TM symbol means that you're claiming common law rights in that mark, okay? You cannot use the encircled R until you have a federal registration, okay? There are state registrations too if you're purely a state-focused business. But you still can't use an encircled R there, and there are some circumstances when getting a state registration makes sense. But a federal registration is what's needed for an encircled R. So there's a lot of, we'll use, what's the difference between Gonzaga and WSU? Okay, there's a lot of differences. We won't even go into the basketball teams. There's no football. Gonzaga football has been undefeated since 1945, apparently. I have a slide in a different presentation. You look at Gonzaga's logo, okay, and there's a TM next to it. You look at the Coug logo, Justin. There's an encircled R, okay. So what does that mean? Well, Gonzaga just has not registered their trademark for certain goods like clothes, okay. WSU has. Okay, and that's what that means. But can Gonzaga go sue someone still if someone else started making Gonzaga shirts with their logo on it? Yes, they can, because they still have common law trademark rights there. Well, and that's a great question. So the common law trademark rights are only as good as the consumer recognition. So they're geographically limited. So if, Gonzaga 20, 30 years ago could probably only go enforce just in the Northwest. Now they could probably go enforce in Maine or Florida or wherever, all around the country, because they're more well known because of basketball. Likelihood of confusion. Are consumers in that location likely to be confused?
Right. So how do you figure that out? You do a survey?
If it came to that in a court case, yeah, survey experts, that type of stuff. It's squishy. It's a squishy right. For patents, there's metes and bounds of the property right. That's the claims. For trademarks, I get right in this mark, but my rights are really kind of this gray circle around it.
I was going to ask if you wanted to give an example of maybe right in our backyard, the Sonic example, or
yeah. So there's two examples of this, and this is interesting. So we'll talk about it, and then we got to move on. But so Burger King, okay, Burger King, the big Burger King, everyone knows about it. Well, there was a mom and pop Burger King burger joint in Mattoon, Illinois, that was there before the big Burger King even started. The big Burger King came and said, "You have to stop using your mark." The little guy actually won, because in their geographic territory, it was like a 3-county area or something, they were known as Burger King. The big guy wasn't. Okay? So they actually won. They got a carved out space where only they could use the mark Burger King, and the big guy couldn't. The converse example of that happened up in Spokane, all right? There's a burrito place by Gonzaga that was called Sonic Burrito, okay? Sonic Burrito, so when I went to Gonzaga, when I heard Sonic, I just thought of the burrito place. I didn't think of the burger, the big national burger place. But now there's a Sonic in Spokane, Sonic drive-through. And before they came, they actually hired one of our colleagues now, and booted the burrito joint off of the name. Well, how could they do that? In Spokane, they were known as Sonic. Well, the deal is the Sonic drive-through had a federal registration before the burrito place started using the mark. Okay? So that federal registration is so important for companies that start in a geographically limited area but have plans to expand nationwide. Okay? So it's real important. Any questions on that, on trademarks, before we move on? Yeah, go ahead. Yeah, that's a good point. So the TM is only for an unregistered mark, a common law mark, but really I think the heart of your question is, should you do the encircled R? Do you have to? Well, you don't have to, but if you want all of the damages afforded by the trademark statute, you need to. So there are several people that, especially, I represent wineries, wine, beer, and spirits clients. A lot of them don't want to put the encircled R or a TM on their label because it doesn't look good. Well, that's fine, but if Coca-Cola can do it, they can do it. You know what I mean? And there are some reasons for doing it. It all comes down to damages if you were to sue down the road. Okay, any other questions?
Does everybody know what damages are? Damages is money that you can potentially recover back during a lawsuit. So, and maybe remedies would be another way of saying that, because it also impacts whether you can get injunctions and statutory damages and other things. So, attorney's fees.
Right. Okay. Up. I got to go down. Okay. Down. So copyright. If patents are the king of IP, copyright's the queen of IP. Copyright's really important and really valuable. Okay. It's so valuable that along with patents, it's actually in our Constitution. Okay. And trademarks are not in the Constitution. They're but copyrights and patents are. The origins are in the Constitution. So requirements for protection. We all are kind of familiar with copyright, right? It's creative forms of tangible, work. So, and I kind of butchered that, but writing. So books, even your notes, definitely pictures, definitely music, right? So requirements. It has to be a tangible form of original expression. That's what I meant to say earlier. So it has to be independent, original creation. So it's not like you're copying someone else. With at least a minimal amount of creativity. So even a phone book is actually subject to copyright protection, even though all it does is list names and numbers, because there's a certain way of laying out the phone book that might be different from one to the next. So there's some copyright protection there. Just like trademarks, you can have protection for you can have copyright protection without any registration at all, okay? And you can start using this encircled C, and then it's encircled C, the year, and the date of last update of the work, and then your name, okay, whoever owns it. Use that right away. But even if you don't use it, there is protection there. As soon as you touch pen to paper and write an essay, you have copyright protection on what you just wrote, okay? As soon as you snap a picture with your phone, you have copyright protection of that. What if I gave my phone to Dave Devine and said, hey, take a picture of me? Who owns the copyright? It's my phone, and it's a picture of me. I should own the copyright, right? I don't. Dave owns it because he pushed the button.
So if
That's
you want
kind of weird.
So if you want to own the picture on your phone that you give to somebody at Disneyland to take your picture, you got to whip out your contract and have them do.
Can you
what's called
assign that to me, please?
Work for hire.
That's right. That's right. So that's a really odd thing, right? So what do you guys? So who's kind of thinking of doing a business with a software component or a mobile app, something? Okay, a couple. Pretty common these days. At least, even non-software businesses have a mobile app or some way to connect to people. So that software code, as Dave mentioned earlier, the code itself is subject to copyright protection. Okay? And it's protectable, it's protected under copyright laws as soon as it's created. All right? That doesn't mean you should ignore a registration. Similar to trademarks, there are some big benefits to registration. And unlike patents, where it's quite the endeavor and costs a decent amount of money to hire a patent attorney to draft a patent application, copyright registrations are easy and cheap. Okay, in fact, I tell a lot of clients that they can do them themselves in most circumstances. You can mess up, and it's a good idea to consult an attorney. But trademarks are relatively cheap compared to patents. The registration and copyrights are definitely very cheap, okay, compared to patents. And what does it give you? It actually gives you a lot, right? So you have the exclusive right to reproduce that work. Okay, to prepare derivative works, to distribute copies, to perform, okay, for certain types of works, to display or even to transmit. Okay, so those are exclusive rights. So think about that. If you have some software and you want to go sell it to a bunch of people, say you start your business, but no one knows how to code software. So what do? Well, you hire someone who knows how to make software, right? Okay, so they create the software for you. They're an independent contractor, not an employee of your business. And you have software at the end. Who owns that? I paid them for it, right? I should own it. They own it unless I get a contract saying that they're assigning it to me. Okay? So that's a big mistake that we usually see people years down the road having to, sort out with their software developers. Wait a second, I own this. No, I do. So software developers, contractors sometimes want a second bite of the apple once you've made it big. I never assigned that to you. If you want it, you got to pay me again. Okay, you got to think about those type of things. That's applicable even if you have, say you guys start your business, you have a core group of owners or founders, and there's another person who, who's even a student here that is a coder, but they're not a founder, and you want to hire them, pay them to do something. You got to get them to assign the rights. Okay. What about someone designing your logo? Logos are covered by trademarks, right? Well, yes. But logos also have design elements to them, and so they're also protected by copyright. And if you have someone else create that logo for you, then they own it, unless there's a contract that says that they assigned it to you. Now, the one difference is if it's an employee acting in the scope of their employment. Then it's a true work made for hire, where that actually the business, the employer owns what the employee creates, okay? But if it's an independent contractor, if you're hiring an outside party, you have to get it assigned. Websites, we have that issue a lot with websites. You have a client that gets a website, and then they decide to use someone else to update it. Well, that original company says, no, you can't do that. That's creating a derivative work, which is it's taking my thing and changing it a little bit. That's a derivative work of my copyrighted work. So that's copyright infringement. Okay, so it costs a lot of money if you don't do it right up front. For copyrights for work made for hire, in a situation where an employee is creating it on behalf of their employer, it's 120 years. And otherwise, it's life of the author, of the creator, plus 70 years. Okay? Any questions? So there's some things that go, copyrighted works that go into the public domain. Anyone know about or ever heard of the Nutcracker Ballet? All right, that was protected by copyright. There was a copyright around that until it expired. And then all of a sudden you're seeing teddy bears doing, butchering this, doing scenes from the Nutcracker, and you see it everywhere because now it's in the public domain. They don't have to pay a royalty, to that, or to the original creator or whoever they assign the rights to. Any questions about copyright? Yeah. Well, it really, okay, so I don't know if I want to go into that really, because copyright should be used more as a noun, right? It's or an adjective. It's copyright, protection. It shouldn't be a verb either way. So technically it shouldn't be either probably, but people use it, including myself. I'm guilty. No, so individual words are not protectable by copyright because it's only the creative expression. And individual words or individual data, sets of data or whatever, cannot be protectable by copyright. It's just the maybe a string of words, how you put them together, right? So a whole, writing a poem or whatever it might be. And the same thing goes for data. Now, this is something a lot of people try to say, I own the copyright in that data that I just collected. Data is not copyrightable in and of itself. The way that it's presented is able to be, protected by copyright. But otherwise, really, data is a trade secret. See that segue? That was smooth, right? Trade secrets. All right, so what are trade secrets? Trade secrets actually protect a lot of the same things that patents can protect. Okay, so information, formulas, patterns, compilations, program, device, method, all these things. In fact, prior to getting patent protection, we normally tell our clients that your invention, before your patent application is published, you should treat that as a trade secret. Okay, you should keep it secret unless you need to, in order to get the business going, you need to tell people about it, for instance. Okay? But there's certain things, the secret sauce behind how you make money, how you are successful in your business, might be a trade secret. So we heard about the Coca-Cola recipe. The Coca-Cola recipe is a great example of a trade secret. KFC, secret seasoning. Okay, that's a trade secret. But there's other things, right? So it could be the process in which you have figured out that the most efficient way for you to order, your supplies for your company is to take this step at these times during the month. And if your competitor knew about that, they would benefit from it. Okay, that's a trade secret. Trade secrets are state law protections, okay? It's under state law, and there's a Uniform Trade Secret Act, and it's only protectable under that state law if it derives an independent economic value. So in other words, your competitor would be benefited, would see some value in having that secret, and it's subject to reasonable means, reasonable efforts to maintain the secrecy. Okay, so maybe for the Coke recipe, it's like eye scanners and guards and whatever, pit bulls. For your, maybe that's what's reasonable for that type of a trade secret. For your trade secrets, maybe it's just limiting the amount of people who know about it, making it password protected, right? That type of stuff, okay? Trade secrets are interesting. There's times when you come up with something, it's an invention that could be patentable. Okay, and you have to make the decision, though, maybe I don't want to patent it, and because the grand trade-off under patent law is you get this 20 years of exclusive, rights to exclude others in exchange for teaching other people what it is you invented, right? But for trade secrets, it's the opposite. You don't want to teach anyone, and so maybe you can actually keep it secret for longer than 20 years. If you can keep it secret, trade secrets are potentially perpetual in duration as well. But it's unlikely these days because of these things, right? Oh, I have a secret, or Dave has a secret process that he has diagrammed out. Snap, press 2 buttons and it's on Twitter, or whatever.
Equally importantly that, in the past you might have people that worked for a company for an entire career, and today that just doesn't happen. The average lifespan of a career is, I think, 4 years now or something like that. So, somebody works at Coke and then they move on to Pepsi. If that trade secret weren't well enough protected, that trade secret just went from one company to another, and the trade secret's gone. Once the trade secret gets out there, there's no putting the cat back in the bag, so to speak. So the trade secret is gone. It's only the only remedy that you would have would be for trade secret misappropriation against that person who took it, and it's unlikely that you're going to recover the value. Another great example that is probably more applicable to some of what you're doing would be if you're developing an app and it has a back-end server component that's really not visible to consumers, that might be something where you would legitimately think about, do I want to seek patent protection for this, or do I want to keep it as a trade secret? And that may be something where you could legitimately keep it a trade secret, at least for a while, and that may be something, particularly if funds are limited, that you'd want to think about doing. Google actually made the decision early on to keep their search algorithm as a trade secret, or at least a portion of it, and that probably paid off for them in a lot of respects. But
a key is if it's able to be reverse engineered, it's not a good candidate for trade secret protection. All right, because if I figure out a new way of putting something together, and then I sell that product, and then someone can just take it apart and see how I did it, then all of a sudden the secret's gone, your protection's gone. So that type of a thing is more appropriate. You want to definitely seek patent protection. Any questions about trade secrets? There's criminal laws too, so don't violate your employer's trade secrets. You could actually go to jail. Yeah, so there's all kinds of different means of keeping a trade secret, and the most common is a non-disclosure agreement. Oh my gosh, what a great segue. That's amazing. You're amazing. That's great.
Can we pause here for just a second,
Yeah.
though? Because I think in terms of our presentation time, the time is kind of up.
Yeah.
So I want to make sure
is it up? Oh, no.
I want to make sure that we give you guys time to ask questions. To the extent you don't have questions, we can absolutely talk about all the rest of this stuff. And maybe we can sort of gradually work through some of it as we field questions. But if you have IP specific or intellectual property specific questions, maybe we can open that up for just a moment and take any questions you have on that specifically. Or if we've already covered them, then I'll let Dan keep talking.
Okay, so non-disclosure agreements are important, okay? Every founder, of your company, should sign some sort of a confidentiality agreement, maybe even a non-compete agreement with the company once it's formed, okay? Because investors or anyone who wants to help you do what you're doing wants to make sure that you're not going to go and just take all the secret sauce that you just developed and use it somewhere else, okay? Non-disclosure agreements come in handy when you're interviewing someone to do your software development or do some outside contracting or potentially investing. Investors will never sign a non-disclosure agreement right away, but if they're interested, so in your presentations, which you'll learn about the next presentation with Andy Barrett and Tom Simpson coming. They won't sign NDAs on the first go-round. So the first presentation, investor pitch, you want to keep it as high level as possible and tell them what it is you do without giving away the secret sauce. Okay, but then once they're interested and they're really want to give you some money, then maybe you have them sign a non-disclosure agreement and you explain all of your trade secret stuff, your potentially patentable inventions, that kind of stuff. So it protects patentability. It's a good way of protecting your IP when there's no formal IP protections yet. Okay. You also want to think about intellectual property assignment. This is another thing that every founder of a company should sign. Okay. Usually we actually prepare a confidentiality, invention assignment, and non-compete agreement. It has it all in one agreement. It says you can't compete with the company, you can't give away the company's secret stuff, and you're assigning everything that you have created up to this point to the company. That's usually what you give to your new company before or in exchange for the ownership interest, whether it be a membership interest in an LLC or stock in a corporation. Okay. So when you hire employees, you want to get an invention assignment before they actually start working for you. Okay, so the day before they start working, or at least right when they first come on the job before they actually start working, you want an invention assignment agreement, because unlike copyrights, where if an employee creates it, then the employer automatically owns it. For patents, it's not that way. The ownership rests in the inventor unless the inventor agrees to assign it, okay? So invention assignment is a really key thing for hiring smart people for your business, okay? And founders should do it as well. Yeah, so that's a good point. I mean, the majority of the people in this room are not going to actually go, run your own business right out of college. You're probably going to work for someone, and a lot of times the employer will ask you to sign something like this, okay? So in Washington State, we have real good laws saying that, look, employers can say, employee, assign everything to me that you create when you're here. But employers cannot take the stuff that you create on your own, okay? As long as it does not relate directly to what you're doing for your company, for your employer. Yeah, so the company might still have rights in what you create if you use your employer's equipment as well. Okay, so say you have a work laptop, and you go and create something that's patentable. Well, maybe there could be a fight there. That your employer could actually have some rights there.
There's several factors that go into it and several doctrines. I mean, I think you've got both the invention assignment right question, but you also have a shop right doctrine that may apply if you're using the equipment of your employer in some cases. All of these things are pretty fact specific, though. I mean, if you're hired for a company to be like the chief technology officer, I would say that anything that you don't specifically exclude from that IP assignment agreement, the company probably owns, because you were brought on to invent. That's your job function at the company. But if you're brought on to be the janitor and you come up with the greatest thing since sliced bread, the company probably can't realistically say they own that.
Yeah, non-compete, so yeah, that's a good point. Anyone who asks you to sign a non-compete, it can't be like forever. You can't compete forever. That's not enforceable. Courts don't like non-competes in general, but it needs to be a reasonable amount of time and reasonable scope. Okay, so it's not like, you can't be if you're a software developer, you can't develop any software ever for 10 years. That's not reasonable. Instead, it should be narrow, like you're not going to develop software that competes with us, okay? So look for that as well.
Another question, but you keep going.
Well, I was just going to say, this is a good example of, there's some products, there's some things that incorporate all different types of IP. So an iPhone, right, has patents, both utility and design patents, trademarks, trade dress, which is the packaging. It's a trademark right on the look, and then copyright as well, of course. What was your? It's of the utmost importance. If you want to own what they create, you must have them sign something. If you don't, then you probably don't own it.
The only thing that I'll add is be realistic about things, though, because if the situation is you're going to buy something that is either an off-the-shelf product or a nearly off-the-shelf product, it's not realistic for you to expect you're going to own the IP on that, perhaps. Whereas,
but maybe the customizations on top of that.
Whereas if it's a much more custom product or something like that, or if you're talking about having them develop an app from scratch, something like that, then certainly you would want to be sure that you protect those things. One other issue, and I don't know if you want to talk about this or not, is with the software too. If you are working with an independent contractor, you want to think about the issue of open source software, because if they're incorporating open source aspects, that may limit your ability to protect that IP in some ways. So you want to think about that and talk about that with your developer and see how they use it. It's not absolute prohibition. You can still get patent protection, but it might limit your copyright protection for that.
Okay, we don't have a lot of time. I'm going to burn through just a couple of ideas here with regard to kind of just corporate legal aspects for startup companies. You want to have an agreement, at the very least, okay? If you don't have a written agreement, then it's a he said, she said type of a thing, okay? If you don't form an entity, then what you have by law is a general partnership. And your business all of a sudden is governed by the Revised Uniform Partnership Act, okay? And you don't want that. You want your agreement to govern, okay? So that's why it's important to talk about things up front. Who owns what? Who's going to have what management authority, okay? Who's going to have what authority, what position within the company? Who's going to be president, CEO, or whatever, right? Okay, vice president, CTO, whatever you want to call it. You want to talk about that stuff up front, and if you don't, then you could have big issues down the road, okay? What about forming an entity? You want to have some sort of a limited liability entity, period. You need to have that if you're going to start a business. Otherwise, you're opening yourself up to personal liability, of the company. Okay, so if me and Dave had a breakfast delivery, a bagel delivery business, and we didn't have a entity, if Dave ran someone over, all of a sudden they could sue me because of what he did. But if we had an LLC or a corporation set up, then they could sue the entity, the LLC, and the corporation, but they can't sue me personally. So I might lose everything that I put into that entity, but I won't lose my kid's college fund or whatever. Okay? So limited liability is key. That's the main reason to form an entity. The other reason is to make an easy vehicle for divvying up equity in the company itself. Okay, who owns what? How much stock or membership interest does each founder own? And then when you have investors, if you have outside investors, how do they get a piece of the pie? Okay. Yeah. Okay, so limited liability period. So what type of entity do you choose? Pretty much, just let's sweep away the noise. It's really down to LLC or a corporation, okay? LLCs are more well-suited for closely held businesses in most circumstances. I'm not saying that's a general rule. Corporations are more well suited for a business that is intentionally going to be an emerging growth type business that requires outside investment. Okay? Investors are more comfortable with the with the corporation structure because there's a required board of directors and required president and secretary and so on and so forth. It's more formal structure that investors like to see, as opposed to an LLC, which provides supreme flexibility where you can call yourself the supreme commander if you want. Okay?
Dan tried to get that on his business cards, but
Yeah. Organizational flexibility versus formalities. It might make sense to do an LLC for a lot of reasons. There's also tax benefits, right? So pass-through taxation. Everyone worries about double taxation of C corps. Oh, that's so bad because you're going to get taxed twice. It's really not a real problem for startup companies because A, startup companies don't make money right away, right? and B, it's actually for corporations, when you lose money, you can retain those losses carrying forward to shield future income, okay, instead of passing those losses and income down to the members for an LLC if it's taxed as a partnership, okay? So we can talk all about that. There's also S corporation taxation, which is kind of a hybrid, but not going to get into that right now. So let's talk about the whole point of all this is in starting a business, you always have to have an eye towards the exit, right? The whole point of starting a business is to make money, right? Or to do something good for society, or there could be philanthropic purposes, of course, too. But for most startup businesses, it's all about some sort of an exit, right? Especially a business that needs outside investment to get going. Those investors are investing because they want to make money eventually, okay? So there's got to be some sort of an exit, whether it be an acquisition, IPO, or otherwise. Okay? So thinking about that up front will pay dividends. Thinking about that up front will pay dividends. Setting up your corporation in a smart way, or your LLC in a smart way up front, will help you greatly on the back end, okay? So having the right founders documents where the founders all assign their rights and agree not to compete or disclose confidential information. When an investor comes to do their due diligence, they want to see those things. Okay, so doing it right up front pays dividends. One thing to remember, if you want to sell equity in your company, if you want to take on outside investors, it's illegal unless you meet an exemption under securities laws, okay? I don't want to, there's laws out there to protect people, my grandmother who doesn't know anything about business from being swindled by, a guy like Dave Devine, who's starting a company, then says, hey, I swear I'm going to make you all kinds of money, just give me your life savings. He's violating securities laws. So what you want to do is find an exemption. The most common exemptions for startup companies are, Rule 506 under Regulation D, which is generally known as an all-accredited investor investment round. Okay. And so an accredited investor is someone who's sophisticated and doesn't need those securities laws to protect them. So someone who makes $200,000 a year in the last 2 years with the expectation of that in the future, or $300,000 with their spouse, or has a net worth excluding their primary residence of $1 million. Okay, those are usually the two most common ways to get an accredited investor. That's why you pitch to people like Tom Simpson, who's coming for the next one. He runs the Spokane Angel Alliance. All of those people who are members of the Angel Alliance are accredited investors, and so therefore it's safe to pitch to them because you don't have to worry about as much about those securities laws. Okay, so just remember that. Even bringing on, selling equity in your company to friends and family is an illegal sale of securities unless you meet an exemption. So the point is, talk to an attorney if you need to sell equity or raise money by selling equity in your company. Okay, it's very important because you personally can be liable actually for if you mess up here. It says you could go to jail. Or personal liability for control persons. Okay, so anyone who's controlling the company or out there selling. Any questions about that? It's real high level right now. If you have questions afterwards, we'll be trying to eat food, I think. Okay, talked about this a little bit. We talked about accredited investors and angel groups. Any other questions about setting up an entity? Okay. No? I think I covered most of the stuff. I think that's it. Questions in general, guys? No? Well, thank you. We'll be here for a little bit to kind of do some networking.